Hello and welcome to the session. Company Law and Corporate Governance LO1 evaluate the nature and legal status of companies. What defines a company as a legal entity? This video explores the nature and legal status of companies, focusing on corporate personality. Discover how incorporation impacts liability, control, and legal responsibilities. Corporate personality grants a company a separate legal identity. This separation was established in Salomon v. A. Salomon & Co. Limited. A company owns assets, is liable for debts, and can sue or be sued. Shareholders' liability is limited to their investment. This principle allows businesses to grow without unlimited personal risk. Business organizations in the UK have varied legal statuses. Sole traders have unlimited liability and no separate legal identity. Partnerships share responsibility, with liability being joint and unlimited. Limited liability partnerships offer limited liability but resemble partnerships. Private and public limited companies have separate legal identities with varying regulations. A company, as a legal person, can engage in contracts and own property. It can sue, be sued, and face criminal prosecution. Liability primarily rests with the company, not individuals. Directors may face liability for serious breaches. Differences in business forms affect liability, continuity, and control. Incorporation registers a company at Companies House, creating a legal entity. Benefits include limited liability and perpetual succession. It enhances credibility and eases access to finance. However, it demands increased regulation and public financial disclosure. Promoters form companies, owing fiduciary duties to them. A company cannot be bound by contracts made before its existence. Promoters are liable unless contracts are replaced post-incorporation. Private companies can trade post-incorporation. Public companies must meet additional requirements before trading. Minimum share capital is essential for public companies. A company's constitution includes the Memorandum and Articles of Association. These documents govern management and decision-making. Companies can be private, public, or community interest. Off-the-shelf companies allow immediate trading. Details need updating post-purchase. Community interest companies aim to benefit the community, not shareholders. They include an asset lock and are regulated by the CIC regulator. Dividend and interest payments are limited. They balance commercial activity with social goals. These companies address community needs. Historically, companies acted within their objects in the memorandum. Acts outside were ultra vires and void. The Companies Act 2006 largely abolished this for third parties. Companies now have unrestricted capacity unless limited in articles. Directors breaching duties may face consequences. Corporate personality means a company is distinct from its owners. Confirmed in Salomon v. A. Salomon & Co. Limited, it allows companies to own property and enter contracts. Shareholders are not liable beyond their investment. This separation supports business growth. It ensures continuity despite ownership changes. Forming a private limited company begins with incorporation. Required documents include a memorandum and articles of association. Form IN-01 details directors and shareholders. No minimum share capital is needed. Companies House issues a certificate of incorporation for trading. Public limited companies face more stringent formation requirements. They need a memorandum, articles, and registration details. At least 2 directors and a company secretary are mandatory. A minimum share capital of £50,000 is required. A certificate of trading is needed before business activities. Corporate personality separates companies from individuals involved. Incorporation processes are similar for private and public companies. Public companies face stricter requirements for investor protection. These processes ensure transparency and financial stability. They reflect the different roles in the economy. Private and public companies differ in ownership and regulation. Private companies have limited shareholder numbers, restricting capital. They offer greater control over decision-making. Public companies raise finance through the stock exchange. This results in dispersed ownership and regulatory obligations. Private companies are owned by a small group, often founders. They cannot offer shares to the public, limiting capital access. This restriction allows more control over ownership. Shareholders influence strategic direction without external pressure. They face fewer legal and reporting requirements. Public companies can offer shares to the public. This provides easier access to capital for projects and expansion. Directors are accountable to a large shareholder base. Share price performance influences decision-making. They face stricter regulation and disclosure obligations. Private companies benefit from fewer legal requirements. They have no minimum share capital and can trade immediately. Public companies need £50,000 minimum share capital. They must appoint a company secretary. These regulations increase administrative costs. Both private and public companies offer limited liability. This protects shareholders from personal responsibility for debts. It is more attractive to public company investors. Large sums are often involved in public companies. Private companies benefit from closer owner involvement. Private companies suit small and medium-sized businesses. They offer control, flexibility, and lower regulatory burden. Owners retain influence over operations. They face less complexity and cost. This makes them ideal for businesses valuing autonomy. Public companies are suited for large-scale growth. They seek substantial investment despite regulatory complexity. Shareholder control is reduced, but capital access is increased. They face higher costs and administrative demands. These companies balance growth ambitions with regulatory exposure. In conclusion, evaluating the nature and legal status of companies is essential for understanding how businesses are formed, operate, and are regulated under company law. A company is a separate legal entity with its own rights and responsibilities, distinct from its owners and managers. This legal status affects liability, ownership, governance, and accountability. By understanding these principles, individuals and organizations can make informed decisions about business structure, compliance, and corporate responsibility, supporting effective management and long-term organizational success. Thank you for watching this video. If you have any questions, please feel free to contact us via email or WhatsApp at 0748 436 1688.